good afternoon, and welcome everybody to our webinar. This is the fourth webinar in the AFSA series, which is entitled The Cutting Edge, and in which we discuss key issues in arbitration. These webinars are presented by AFSA founding members who are leaders in the field, and we're delighted that Willkie Farr Gallagher have agreed to present today's webinar titled Drafting Effective Arbitration Clauses. Willkie Farr Gallagher are an elite international law firm with a history, I'm told, going back 130 years. They operate out of 13 offices in 6 countries and are staffed by approximately 1,000 lawyers. Well, the members of today's panel are Duncan Speller, a partner in Willkie Farr and a leading practitioner in international arbitration. With him is Elliot Cooper, a barrister and solicitor specializing in international arbitration, and Jack Davies, an associate specializing in commercial and investment treaty arbitration and cross-border litigation. We all know, I think, that the success or failure of arbitral processes depends to a large degree on the quality of the arbitration agreement which governs the process. And so we look forward to hearing the panel's insights of how an effective arbitration clause should be put together. Thank you, and over to the panel.
Good afternoon, everyone. It's a great pleasure to join you this afternoon, and it's a great pleasure as well on behalf of Willkie that we are a founding member of AFSA. AFSA serves the eminently worthy objective of promoting the fair and efficient resolution of disputes privately. And having prepared this session, I reviewed the AFSA rules, and I think the AFSA rules reflect international best practice in terms of a set of arbitration rules that provides a framework for the fair and efficient resolution of disputes. Today, we will address the important practical issue of how parties can incorporate these rules in their contract. Arbitration is predominantly a creature of contract, and that is to say that parties submit to arbitration consensually by selecting a set of arbitration rules such as the AFSA rules. And therefore, it is important that the parties get the contractual language right, and that the arbitration agreement, which typically records the parties' agreement to refer disputes to arbitration, accurately reflects their intention. Often we find that in commercial transactions, parties leave the drafting of the arbitration clause to the last minute. The parties record on their substantive deal and at the last minute focus on the dispute resolution provision. In our experience, this is a mistake. Substantive contractual rights only have value to the extent that there is an effective mechanism for enforcing those rights. The rights you have in your contract only have value if there is a dispute resolution provision through which you can enforce them if your counterparty does not comply. And this is why the agreement to arbitrate is so important, and it is why it is so important that the parties address the agreement to arbitrate at the drafting stage. Today, we will provide you with an overview of how to do that, a step-by-step overview of how to incorporate the agreement to arbitrate into the parties' contract. I will start by discussing some of the essential elements that should be contained in any agreement to arbitrate. My colleagues, Elliot Cooper and Jack Davies, will then address some optional additional elements the parties may consider incorporating. we will also address some specific features of the AFSA rules. And as I say, I think the AFSA rules reflect international best practice and record innovations that have been developed over the last 3 or 4 years in a number of arbitral centres. But it's important that parties are aware of those innovations and how to use them. We have on the slide before you a step-by-step guide as to how parties can draft an effective agreement to arbitrate. The first step is typically to start with the model arbitration clause of the relevant arbitral institution, such as AFSA. This is available on the AFSA website. The next step is to ensure that the essential elements of the agreement to arbitrate are covered, and I will address what those essential elements are. The next step is then to address whether to include optional elements. And as the word optional suggests, these are not necessary in every case, but parties may consider incorporating these elements based on the particular circumstances of the case. Finally, parties should consider seeking specialist advice. And this can be provided quite quickly and efficiently, but particularly in complex transactions where there are multiple contracts or multiple parties, it may be advisable to seek specialist advice to ensure that the arbitration provision reflects the intention of the parties and provides the optimal provision for the resolution of a particular dispute. So, as I've identified, in drafting an arbitration provision, the best starting point is typically the model arbitration clause published by the relevant arbitral institution. The model arbitration clauses are intended to provide a tried and tested solution. They're developed by the arbitral institution, such as AFSA, to provide clear and simple language recording the party's intent to arbitrate. And in my experience, one of the most common mistakes commercial parties make is thinking that the arbitration clause needs to be too long or complicated. In general, simplicity and clarity are highly valuable in the arbitration provision, and the model clause, such as the AFSA model clause we see on the screen, is intended to provide a clear and simple starting point. And as we see from the language, it's very straightforward. It records that any dispute arising from or in connection with this contract shall be referred to and finally resolved by the Arbitration Foundation of South Africa in accordance with its international arbitration rules. That language records in unambiguous, clear and succinct terms the party's intention to arbitrate and to incorporate into their contract the AFSA arbitration rules. So that is the best starting point to take the model clause of the institution. And having taken that, the parties should then ensure that each of the essential elements of the agreement to arbitrate are included. And I've identified on this slide the essential elements to include in any agreement to arbitrate. I'll touch briefly on those, and later on we will have a revised version of the AFSA model clause, including each of those essential elements, which demonstrates how in practice parties can start with the AFSA model clause, include all the essential elements, and then this provides a good basis to consider whether to include any of the optional elements. So what are the essential elements of the agreement to arbitrate? Well, firstly and fundamentally, the agreement to arbitrate should unambiguously record the party's intention to arbitrate. As I've said, arbitration is a creature of contract, and it's therefore important that as a matter of contract, the parties clearly and unambiguously record their intention to submit disputes to arbitration. And the AFSA model clause does this in mandatory terms. We see the language on the screen that any dispute shall be referred to and finally resolved by AFSA in accordance with its international arbitration rules. So that addresses the first essential element, recording the parties' unambiguous intention to arbitrate. The second important element is that the arbitration clause clearly and unambiguously defines the scope of the disputes the parties agree should be subject to arbitration. Again, this is a consequence of arbitration being a creature of contract, that the parties need to record exactly what disputes they're agreeing to submit to arbitration. Generally, it's advisable to use broad language, stating that any dispute arising from or in connection with this contract should be referred to and finally resolved by AFSA in accordance with its international arbitration rules. That broad language makes clear that both contractual and extra-contractual claims connected to the contract are subject to arbitration. That broad language prevents a counterparty from seeking to commence proceedings in a national court by arguing that only some disputes are subject to arbitration. Occasionally, it is advisable to have carve-outs for specific issues, subjecting specific issues to a separate dispute resolution procedure. A common example is intellectual property disputes or trademark licensing disputes, where the parties may wish to have a specialist decision maker. Our advice would be that where parties have a carve-out, it should firstly be carefully considered and for a good reason, such as subjecting a specific set of disputes to a specialist decision maker. And secondly, the carve-out should be clear. Again, it's fundamental that the arbitration clause should clearly identify the scope of the disputes which should be subject to arbitration. The third essential element in the arbitration agreement is that it should specify the seat of the arbitration. The seat of the arbitration is the place legally where the arbitration is conducted. Parties often think that the seat is just where geographically the arbitrators sit. In fact, the seat has far broader legal consequences, and the parties can actually conduct the hearing at a venue other than the seat. The seat defines the legislative framework that applies to the arbitration. So, for example, when the parties agree to South Africa as a seat for their arbitration, the parties agree that the arbitration will be subject to the legislative provisions of the South African Arbitration Act 2017, which addresses such important issues as the arbitrator's duty of independence and impartiality, when national courts can intervene in support of arbitration by, for example, granting interim measures, and when the arbitral award can be challenged or set aside. Similarly, when the parties agree to arbitration seated in England and Wales, parties incorporate the English Arbitration Act 1996. So the seat is actually an important legal and strategic choice. What considerations should parties consider in choosing the seat? It's critical that the seat should be a party to the New York Convention, as indeed over 170 nations, including South Africa, and most nations in Southern Africa are, because this enables the arbitral award to be enforced across national borders. If the seat is a signatory to the New York Convention, an award obtained in that seat can be enforced in 170 or so other New York Convention states, and the relative ease of enforceability of arbitral awards is one of the most important practical advantages of arbitration. It's also important that the seat, the legislation of the seat, facilitates the arbitration by minimizing judicial interference in arbitration. And the 2017 South African Arbitration Act, which is based on the UNCITRAL model law, achieves those objectives. And I think the 2017 legislative changes in South Africa have done a great deal to promote South Africa as a seat for arbitration by enshrining an international best practice law that minimizes judicial interference in the arbitral process. So the choice of seat is important, and the key issues are that the parties should choose a well-established arbitration seat, which is a signatory to the New York Convention and has a legislative regime that is supportive of international arbitration. South Africa meets those criteria. England and Wales meet those criteria. There are a number of well-established international arbitration seats that the parties can opt to select. The next important element is that the arbitration clause should specify the law applicable to it. And the law applicable to the arbitration agreement is not necessarily the law applicable to the rest of the contract. This is because of a principle called severability, which means that in principle, the arbitration clause is severable from the underlying contract, such that the invalidity of the underlying contract doesn't necessarily mean that the arbitration clause is invalid. And it's advisable for the parties to expressly specify the law applicable to the arbitration agreement. There have been sort of several recent cases that have been up to the United Kingdom Supreme Court where considerable confusion as to the law applicable to the arbitration agreement was created as a result of the parties' failure to specify this. And in fact, the English and French courts reached diametrically opposed conclusions on which law applied to the arbitration agreement. The English courts concluded it was English law, the French courts concluded it was French law. And this spawned satellite litigation that went on for a number of years. The parties could have avoided this simply by specifying in clear and unambiguous terms what the law applicable to the seat is, as you see on the screen. The next important element is that the arbitration agreement should specify the number of arbitrators and how they are to be appointed. This is a critical element of any international arbitration. The arbitrators are the people who will decide the dispute on the merits. The applicable arbitration rules, such as the AFSA rules, will contain a default provision. The AFSA rules provide for a default position that there shall be one arbitrator selected by the AFSA court unless the parties agree otherwise. Commercial parties, in our experience, particularly in larger contracts, often prefer to have a tribunal of 3 members. This ensures that each side has the opportunity to nominate one arbitrator for confirmation by the AFSA court, and that there will be a neutral chair, either selected by the parties or their co-arbitrators, or by a neutral institution such as the AFSA court. So the parties can specify the number of arbitrators, can specify that they wish there'd be 3 arbitrators, and can, in their agreement to arbitrate, provide a mechanism for the appointment of the tribunal. Parties sometimes include in agreements to arbitrate specific qualifications or characteristics the arbitrators should have. These should be considered carefully because they narrow down the potential pool of arbitrators for a particular dispute, and the parties won't necessarily know in advance what specific disputes may emerge from a contract. I mean, for example, just because a contract is an intellectual property licensing agreement doesn't necessarily mean that every dispute under that contract will be technically complex and require particular expertise. There may be a payment dispute under the contract. So in general, we would err on the side of caution in terms of including specific characteristics, and it's more central to ensure that there is agreement on the number of arbitrators and a process for the appointment of the tribunal. It's important that the arbitration clause should specify the language, and the AFSA rules provide that the default shall be that the language is English unless the parties agree otherwise. In our experience, it's advisable for the parties not to have a bilingual arbitration. And we've seen a number of cases which provide for bilingual arbitration and for documents submitted in the arbitration to be submitted in both languages. And this can significantly increase expense, as well as, again, limiting the pool of arbitrators, because the arbitrators will need to be fluent in both applicable languages to the arbitration. The arbitration agreement should specify the institution that the parties have selected, for example, AFSA. The advantage of selecting an institution is that the parties incorporate by reference the rules of that institution, such as the AFSA rules, and those provide a default set of rules that keep the arbitration operating smoothly. Sometimes parties agree to ad hoc arbitration. This is arbitration where there is no institution such as AFSA administering the arbitration, and there is often no default set of rules. This can, in practice, mean that it is more difficult in the early stages of the arbitration to proceed because there is not a fallback provision. So there are significant practical advantages to institutional arbitration. As I've said, and we'll explain in more detail, I think the AFSA rules reflect international best practice in terms of incorporating innovations that we've seen in the last 3 or 4 years in terms of interim relief, emergency arbitration, and third-party funding, and provide a good default set of rules to keep the arbitration operating smoothly. So I've covered the essential elements that an agreement to arbitrate should include. And as I said, the best starting point is the model clause of the arbitral institution, such as AFSA, and the parties can then use that model clause and ensure that they incorporate each of the essential elements of the agreement to arbitrate. And up on this slide, we see the AFSA model clause, including each of the essential elements. So ultimately, as you see on the screen, the agreement to arbitrate is pretty short and straightforward. It simply takes the AFSA model clause and ensures each of the essential elements I've identified is included and is expressed in clear, unambiguous, and succinct terms. And this is an excellent starting point for the agreement to arbitrate. The parties can then come on to address whether to add to this template any optional additional elements. And this is a strategic decision parties should reach based on the particular circumstances of the case. And my colleagues, Jack Davis and Elliot Cooper, will go on to address these optional additional elements which the parties may wish to include.
Thank you, Duncan. So as mentioned, my name is Elliot Cooper, and along with my colleague Jack Davies, we will speak to the optional elements. And so as Duncan mentioned, contractual parties are well advised to consider whether, and if so, which optional features should be included in an arbitration agreement. And ultimately, this will depend on considerations relevant to the particular contract which is being negotiated. And in fact, this may include the nature of the transaction, the identity of the counterparty, and the types of disputes that may arise, for example. So we're going to discuss the 6 optional features included on this slide in particular. We'll work our way around clockwise. I'll speak to the first 3, and then Jack will address the second 3. So the first optional feature is confidentiality. So in certain jurisdictions, such as England and Wales, there is a requirement that arbitration proceedings are kept confidential. However, this is not a universal standard internationally, and even in jurisdictions which do impose a duty of confidentiality, the precise scope and content of that duty can vary. So as a result, in many cases, parties should consider whether to include express confidentiality obligations in the arbitration agreement. This will ensure that the scope of confidentiality is clearly defined and that it applies to all the aspects that the parties intend to be kept confidential. So confidentiality obligations could, for example, extend to the aspects which have been listed on this slide. So the fact of the arbitration, the information disclosed during the arbitration, and any materials prepared in the context of settlement discussions. And it's also important to note that the AFSA rules do include default confidentiality obligations in Article 36. So these obligations will apply unless there's party agreement to the contrary. And the particular scope of the obligations extend to all awards in the arbitration, all materials in the arbitration that have been created for the purpose of the arbitration, and all other documents produced by another party to the arbitration that are not otherwise in the public domain. The next optional feature is alternative dispute resolution, or ADR procedures. And contractual parties may agree that before commencing any arbitration, they must engage in certain ADR procedures. An example of ADR procedures is a requirement that parties negotiate in good faith for a defined period before commencing arbitration. And in some circumstances, ADR procedures can provide an efficient mechanism to enable parties to resolve disputes amicably and efficiently. Such provisions requiring ADR procedures, they must be clearly and unambiguously drafted, and they should specify what procedures must be complied with and whether or not the specific procedures are mandatory preconditions that must be satisfied before a party can commence arbitration. When provisions which require ADR procedures are poorly drafted, they can have significant downsides. And a couple of examples. For one, unless settlement is reached, ADR procedures will not result in any binding judgment or award. And in that case, such procedures may just result in increased costs and delay the resolution of the particular dispute. Another potential downside is that ADR procedures could give rise to collateral disputes. So for example, whether the procedures have been properly complied with before commencing arbitration and whether an arbitral tribunal has jurisdiction over the relevant claims. And the third optional feature is interim measures. So in some circumstances, parties may wish to seek interim measures to safeguard their substantive rights, either before or after the commencement of arbitral proceedings. And parties can seek interim measures from the arbitral tribunal if it's been constituted, or from national courts. So to provide an example, a party may be concerned that the opposing party intends to dissipate its assets in an effort to frustrate the efficient enforcement of any resulting award. So the concerned party could apply to the tribunal or to a national court, as may be the case, for an interim order freezing the opposing party's assets to ensure they cannot be dissipated. And most national laws and institutional rules grant arbitrators the power to order these and other types of interim measures. So the AFSA rules are a prime example, with interim measures addressed explicitly in Article 24. So Article 24 grants arbitral tribunals the power to order any temporary measure, and the tribunal's powers are expressly stated as not affecting a party's rights to apply to national courts. And with that, I will hand over to Jack Davies to address the next three optional elements.
Yeah, thank you very much, Elliot. So as both my colleagues have said, my name is Jack Davies. I'll be talking to you about the final three optional elements that parties are well advised to consider inserting into their arbitration agreement, before finally touching on some unique provisions of the AFSA rules. And then finally, I'll hand back over to Duncan for any concluding comments before we take any questions that you may have. So the fourth optional element that we'll be addressing is document production. And obviously, this can be a very, very useful tool or unhelpful tool, depending on what side you look at it from in arbitration. The ability to seek helpful documents from the other side can very well tip cases in parties' favour, and likewise, if you're forced to disclose adverse documents, well, that can have a very negative effect on your case. And so in our experience, while sort of what we might call broad US style discovery is very, very seldom permitted in international arbitration, some document production is generally allowed by international tribunals. It's important to note that this is an issue on which the AFSA rules are silent. So parties are very well advised to consider defining, at least to some extent, the scope of document production or the use of evidence will be permitted in their arbitration agreement. In our experience, it's often, or parties often will choose the IBA rules on the taking of evidence. Under these rules, parties are entitled to make document production requests of each other. These requests must be narrow and specific, either for a document or category of documents. They must demonstrate that the other party is likely to have these documents in their possession. And of course, the documents must be relevant and material to the dispute. It's important to note that the IBA rules are certainly not the only position that parties can opt for. There are a range of alternatives or specific features parties might consider including, whether these are the 2018 Prague rules, for example, which were devised to provide an alternative to the IBA rules, in which are perhaps slightly stricter in terms of when documents will be disclosed. Parties might provide for the use of oral depositions, which are more common in the US than at some other jurisdictions. But of course, like any provision that goes that parties insert into on top of a model clause, it should be as narrow and as specific and clear as possible as to what's being provided. The fifth optional element we'll talk about is multiple contracts and third parties. So this option is really relevant to where you have sophisticated or large commercial transactions that involve perhaps a series of contracts between interrelated or similar parties, or scenarios where you might have a contract between two parties, but other parties, although not strictly a party to the contract, have significant involvement in whatever the contract provides for. And so there are sort of two relevant, two of the concepts most commonly discussed sort of under this broad heading are firstly the consolidation of arbitrations into one single arbitration, or joinder/intervention, where a third party will be joined to the arbitration by either the claimant or respondent, or a third party will apply to, i.e. intervene, apply to join a pre-existing arbitration. It's worth noting that the AFSA rules contain extensive provisions on these issues, and these are contained in Articles 28 to 30 of the AFSA rules. And what they try to do is sort of avoid the same factual scenario where there might be several parallel arbitrations ongoing, but which touch on very, very similar facts, and where there is a risk of conflicting decisions, duplication of work, and just unnecessary costs, expense, and delays. And so while the AFSA rules do contain extensive bespoke provisions, the parties may want to, they're well advised to consider whether these provisions are suitable for their particular fact scenario and the parties they're dealing with, and are well advised to take specialist advice on these issues. And on this, we just sort of advise, there are 2 points that we've seen come up in practice that parties are well advised to bear in mind. The first is if you're sort of negotiating a series of contracts, and it might be contemplated that if individual arbitrations were initiated under each one, and that at some point down the line it might be beneficial to have a consolidation of those arbitrations, that all the arbitration agreements are actually compatible. We've seen cases where they're not, and on which consolidation has been denied. And secondly, while it may seem at the outset like a good idea to provide for the ability to join third parties, parties are well advised to consider whether that third party might be obstructive. And we've certainly seen cases where a party's been joined as a third party, but instead has just completely delayed resolution of the dispute by throwing up delays that wouldn't have been thrown up had that party not been joined. And the final optional element I'll touch on is sovereign immunity. We can deal with this one pretty briefly. I think it's very, very common in, I would say, most jurisdictions from states or state entities to have both what is called immunity from suit and immunity from execution, which are often talked about under the sort of broad heading of sovereign immunity. Immunity from suit means they can't be sued. And secondly, immunity from execution generally refers to being immune from any application to try and attach or seize enforced judgments or arbitral awards against state assets. So parties are well advised, if contracting with a sovereign state or a state entity, state agency, or any body that might arguably fall into that category of entity, to obtain a waiver of sovereign immunity in their arbitration agreement. And parties should also ensure that the waiver is effective under the laws of all jurisdictions where enforcement may be sought in relation to both immunity from jurisdiction and immunity from execution. And then finally, as noted, I'll just touch on some specific features of the AFSA arbitration rules. And sort of just as a broad comment, the 2021 AFSA International Arbitration Rules are, as you'd expect from rules that were only effective as of last year, very, very up to date with most of the sort of provisions that have been discussed in a lot of the recent arbitration literature. And I'll just touch on three particular provisions that parties are well advised to be aware of. So the first is emergency arbitration in Article 11. This allows for parties to apply for an emergency arbitrator to be appointed before the formal appointment of an arbitration tribunal. And these kinds of provisions were inserted into many arbitration rules to address a perceived weakness that perhaps national courts might be better or more able to award interim measures where a tribunal could not be constituted in time. So now we have the ability to apply for the appointment of an emergency arbitrator. Similarly, the ability to apply for early dismissal in Article 12. And here, parties are able to apply to the tribunal for early dismissal without going through the formal procedures of an arbitration on one of two grounds, which are set out there on the slide. And again, these provisions were inserted to address a perceived weakness that perhaps some national courts, and particularly common law courts, had an ability to award or to strike out or grant summary judgment for claims that were clearly vexatious or outside the tribunal court's jurisdiction. And finally, third-party funding. We, in particular, have definitely seen a growth of arbitration claims that are funded by third parties, whether professional litigation funders or arbitration funders or otherwise. But it's important to note that under Article 27 of the AFSA rules, if a party is funded by another third party, they must disclose at the minimum, A, the existence of the funding agreement, and B, the funder's identity. So with that, I'll hand back over to Duncan for any concluding comments before we take any questions.
Thank you very much, Jack. So in conclusion, drafting the arbitration agreement is a fundamental part of any contract, but is ultimately relatively straightforward in many cases. We've provided a step-by-step guide to that process. And as we discussed at the outset, the best starting point is to take the model arbitration clause published by an arbitral institution such as AFSA, which is available on their website, then to consider each of the essential elements and ensure each of the essential elements we've identified are included, and then to consider whether to include any of the optional elements. And if commercial parties adopt that step-by-step approach, the process of drafting the arbitration clause becomes much more straightforward. As I've identified, a common mistake commercial parties make is making clauses overly complicated. And when the parties opt into a set of institutional rules, such as the AFSA rules, that will already contain solutions for many practical issues the parties will come across in an arbitration, such as early dismissal, such as third-party funding. Parties should only vary those institutional rules for a specific purpose and intentionally. And finally, if in doubt, it is very quick and efficient to obtain specialist advice on drafting arbitration clauses. We frequently advise commercial parties on drafting. We have the benefit of having seen the types of ambiguities that give rise to disputes and ensuring that those issues are avoided, ensuring that the arbitration clause is clear and simple, and that it reflects the intention of the parties at the drafting stage, can avoid protracted jurisdictional disputes in the long run. So ultimately, this is, hopefully we've demonstrated in a step-by-step way that drafting arbitration clauses is important, but there is a relatively clear and efficient way of ensuring that the clause is clear and reflects the intention of the parties. It's been a great pleasure to speak with you all today, and we'd be delighted to answer any questions that anyone has arising from our presentation.
So there's one question on the Q&A. I'm not sure if you have access to it. If not, I could read it out to you.
I can see, yes, I can see the question. If the seat is clearly identified, in what circumstances will the governing law of the arbitration agreement need to be specified? Isn't the law of the seat automatically the law of the arbitration? This is a very good question, which touches on the recent English case law I've identified, which conflicts with French case law. And the short answer is that it is advisable in all cases to specify the law governing the arbitration agreement, because it is not automatically the law of the seat. And the different courts have adopted different approaches. In one of the recent English cases, which went up to the English Supreme Court, the parties had agreed to arbitration seated in Paris, but the contract was governed by English law. The parties then had an arbitration seated in France. The tribunal concluded, applying French law, that a third party, non-signatory, was in fact bound by the arbitration agreement. There was then a challenge in the French courts to set aside the award of the seat. The French courts concluded that the law governing the agreement to arbitrate was French law because the seat was in France, and that under French law, this non-party signatory was bound, and therefore the award was upheld. So the French courts did apply French law as the law of the seat. When enforcement was sought in England, the counterparty resisted enforcement on the basis that English law should apply, because the contract was governed by English law, and presumptive and impliedly the parties intended English law to apply to the agreement to arbitrate as well, notwithstanding that the seat was France. So the English and French courts reached quite different conclusions. So the short answer to the question is no, it's not clear that the law of the seat automatically governs the agreement to arbitrate, and the best route to avoid disputes as to what law should govern the arbitration agreement is to specify it expressly. And as we've done in the slide, this can be done quite simply in a short sentence in the agreement to arbitrate that will remove these ambiguities and potential for different legal systems to adopt different positions as to what the governing law is. And even if the law of the seat is relatively clear, enforcement may be sought in other jurisdictions, and those jurisdictions may adopt different approaches to what the law governing the agreement to arbitrate in. So those issues can be avoided by a simple express specification as to what the law governing the agreement to arbitrate is.
Thank you. I wonder if we're receiving any other questions at this moment. Please understand that you can submit questions after the session is over, and we'll ask the panelists if they would be kind enough to answer, even though it comes a day or two later. But are there any other questions immediately available? I then not only thank you, but make an announcement. So Duncan, Elliot and Jack, thank you very much indeed. It's a clear, authoritative guide that you've given us all to the creation of the arbitration agreement, the arbitration clause, which, as we all know, is the fundamental building block in a viable arbitration process. The proceedings today in this webinar have been recorded, and they will in a few days be available from the AFSA website. And we would encourage all those who've registered and all those who've missed registration today, please to take advantage of listening again to the very careful and the very helpful guidance that we've received from our panelists today. Thank you all, and thank you very much.